Are verbal agreements for small purchases legally binding? If you shake hands on a $300 deal, can it be enforced in court? The answer might surprise you. Oral agreements can indeed be legally binding, even for transactions under $500. However, proving their existence and terms can be challenging without written documentation. Under the Uniform Commercial Code, or UCC, contracts for goods valued over $500 generally require written documentation. This means that for smaller transactions under that threshold, verbal agreements are typically sufficient from a legal standpoint. For any contract to be valid, whether written or oral, it must contain 4 essential elements. First, there must be a clear offer from one party. Second, the other party must accept that offer. Third, there must be consideration, meaning each party provides something of value. And fourth, both parties must intend to create a legally binding agreement. Despite the legal validity of oral agreements under $500, certain types of contracts must always be in writing under the statute of frauds. These include contracts for selling or leasing land, marriage contracts, agreements to pay someone else's debt, and contracts that take more than 1 year to complete. Even when the UCC requires written contracts for goods over $500, several exceptions exist. Specially manufactured goods that cannot be resold to others may be covered by enforceable oral agreements. If a party admits in court that a contract existed, this can validate an otherwise unenforceable oral agreement. And partial performance, such as making a payment or delivering goods, can establish the existence of a contract. When disputes over oral agreements reach court, evidence becomes crucial. Witness testimony can significantly strengthen a case. If someone was present when you made the agreement and can testify to its terms, this provides valuable corroboration. Course of conduct also serves as evidence. If you've already taken actions consistent with the agreement, such as making payments or accepting services, these behaviors demonstrate the contract's existence. For example, if you pay for newspaper delivery for a week, you cannot later claim no agreement existed. Credibility plays a major role in oral contract disputes. Courts assess whether each party's claims are believable based on common practices and reasonable expectations. For instance, claiming you thought restaurant food would be free would likely be deemed incredible by any court. While oral agreements under $500 can be binding, they come with significant risks. Without documentation, disputes become one person's word against another's. Misunderstandings about exact terms are common. Human memory fades over time, leading to different recollections of the agreement. And proving that the other party failed to fulfill their obligations becomes much more difficult. The bottom line is that oral agreements under $500 are legally binding, in theory, but often problematic in practice. Even for small transactions, putting agreements in writing eliminates ambiguity and provides clear evidence of the terms. This simple step can save significant time, money, and stress should disagreements arise later. If you find yourself in a dispute over an oral agreement, gather any supporting evidence such as text messages, emails, receipts, or witness statements. These pieces of evidence can help establish the existence and terms of your verbal contract. Remember that while the law may recognize your $500 handshake deal, having something in writing is always the safer approach to protecting your interests.